everyone. So I'm excited to kind of shift gears a little bit and back to the domestic side of things. I spent my summer in Atlanta at the Southern Center for Human Rights, but a lot of my work was actually in Alabama. So I was on the road a lot, and I'm hoping I can kind of fit some of that into my presentation today that's focused on parole and whether or not we might have more room for due process in the parole consideration context. So it's no surprise that the United States incarcerates more people per capita than any country in the world. Our prisons are overcrowded and people are languishing in prisons and jails across the country. There's also an important conversation to be had around sentencing reform. There also is a worthwhile conversation to be had about pursuing alternatives to prosecution when appropriate. Another mechanism to tackle decarceration is also using the mechanisms we have for early release, and one of those is parole. So parole allows an individual to be released before they have completed the maximum amount of time on their sentence, and they are released under supervision. And I think that's really important to point out that it is still a continuation of state control and policing and surveillance that primarily does target communities of color that are already highly policed in this country. However, in the United States, there is a long history of considering parole what we call a matter of legislative grace. So it is not a right, it is a privilege. And so our courts do not recognize robust due process safeguards and protections for individuals who are coming up for parole consideration. If someone has been released and parole is being revoked, then due process protections come into play. But however, when someone is currently incarcerated and goes before a parole board, there are very few due process protections for those individuals. And that's quite ironic because in many ways, the parole consideration process resembles sentencing in the sense that we are talking about a decision-making body determining whether an individual should spend more time in prison or should be allowed to regain their freedom. With very few due process protections also comes very little uniformity across the country in terms of how parole decisions are made. So parole boards can make up anywhere from 2 to 5 parole board members. But the way that individuals become eligible for parole varies a great deal across the United States. The factors that come into play to determine whether someone is suitable for parole varies a great deal. Sometimes these decisions are made over a few minutes with very little deliberation. Sometimes it's a day-long process. Sometimes individuals who are applying for parole are actually interviewed and they engage in a conversation with the parole board. Sometimes that individual is not even present in the room and has no opportunity to engage with the board that is going to decide whether or not they will be given an opportunity to be released to society. And so my case study today really is Alabama, and I'm not picking on Alabama because anything particularly unique is happening in Alabama in terms of how they're handling parole decisions. Actually, a lot of the issues that we see in Alabama on the ground can be translated in other parts of the country. A lot of the issues are the same. And I'm also not picking on Alabama because it's the state with the third level, highest level of incarceration in the United States, but that is worth noting. And the reason why I'm choosing Alabama is because I actually had the opportunity through this grant to advocate for an individual before the parole board. So in doing that, I drove about 5 hours one way to meet my client in the prison that he was being held. And I got to know him in a few hours. Our time was limited together, but I was able to get a sense of who he was, how he had come to be in the situation that he was in, what he had done with his time in prison, and where he was hoping to go. And with that, I was also able to get a better sense of who was supporting him inside the prison, who could I talk to, what wardens had he worked with, who might be able to write some letters of support. I was also able to work with his family to get some support letters and speak with them about what his transition plan would be if he were released. And I was able to put this together in a packet that went before the board 24 hours before my hearing. And then I traveled to Montgomery, where the hearings are all held in the state of Alabama, and gave a pitch that lasted about 4 to 5 minutes. giving sort of the best reasons why this individual was ready to be given a second chance, and really spoke about what he had done during his time, the insights he had gained about himself, and how he hoped to contribute meaningfully to society. And we were successful. He was granted parole, and he's now out, and he has been for several months. He's still doing really well, last I heard. The biggest thing that I'm left with from the experience is that when the parole board immediately made a decision within a few minutes after deliberating amongst themselves, sort of in a room like this, was that I couldn't turn to my client once that decision had been made. He was not in the room, and he was not allowed to be in the room. And so he was not allowed to speak or address the board in any way, and he's also not entitled to counsel. So there is no system in place to allow individuals who are up for parole to have legal representation in Alabama, like in many states across the country. And this, for many, I think, obvious reasons, creates a problem in terms of humanizing the individual. And so if the individual doesn't have an advocate who steps up to come to the parole board meeting and make a presentation for why they should be released, they make a determination based on a paper file. And it's very easy to make a decision against that individual if they're not in front of you and not there to really speak for themselves and to humanize that person. And I wanted to just bring your attention to kind of what's happening in Alabama. Since I've left the area, things are actually on hold right now because they canceled parole hearings for a little while as a result of the governor placing a moratorium on early parole releases. And so there's a little bit more attention on the process in Alabama and what's happening and how these decisions are made. However, I'm afraid that yet again in this moment we're probably not going to be having a conversation about due process or how to elevate the sense of humanity in this process. And I think it's important to remember that a parole hearing is not an opportunity for resentencing. It's not an opportunity for a district attorney to retry a case. But we really should be focusing on the individual in question, what they've done with their time, and the potential that they have to rejoin our society and make meaningful contributions. Thank you.
So hi everyone, my name is Jennifer and I'm a JD candidate at the UCLA School of Law. And this summer I did my fellowship at the Center for Constitutional Rights in New York City, which is a civil and human rights organization that works to advance the principles of the U.S. Constitution and the Universal Declaration of Human Rights. They're perhaps most famously known for litigating the stop and frisk case against the New York Police Department in New York City. So for my project, I was curious about looking at the ways that the international human rights framework is incorporated to the movement against police violence here in the United States. So when we think of human rights in the United States, there is sometimes a strong sentiment that seems to be rooted in U.S. exceptionalism, that international human rights bodies are maybe just not as relevant or not as necessary in the United States because we have the United States Constitution and then we also have the federal courts to vindicate our rights. Additionally, the U.S. has traditionally been less vulnerable to international scrutiny when it comes to human rights. The language of human rights itself is often associated with abuses that occur abroad. Another challenge is that folks simply aren't as familiar with the application of international human rights law to addressing America's social problems. So the issues of discriminatory policing and mass incarceration in the United States sort of disrupt this image of the U.S. as having a very exemplary human rights record. And the challenge is for us to be more accountable for the violence and injustice that occurs right here at home. So since August of 2014, the killing of Michael Brown in Ferguson, Missouri has really brought this conversation into the national discourse. We all know the movement Black Lives Matter has started a national dialogue on anti-Black police violence, misconduct, and militarization. Despite this mass movement, law enforcement officers are often not held accountable. So they're not often charged with homicide in the criminal courts, and frequently it's very difficult to get civil liability in the federal courts. So in short, there are significant limitations to American constitutional jurisprudence and the anti-discrimination tools that we have. So when I started my work at CCR this summer, I was curious in researching how organizers have incorporated the human rights framework into this fight, what this work has done, and what the path looks like moving forward. So CCR attorneys, they consider themselves to be movement lawyers, and that means that they work alongside movements. So they support movements, they litigate when necessary, but any efforts that the attorneys put in to assist movements, it's always the organizers who come first. So I used my time at CCR to build relationships with some folks who have familiarity with the utilization of the human rights framework in addressing these issues and just getting a better understanding of this advocacy strategy. So from having these conversations, there really were 3 important takeaways. For one, organizers and people who are directly impacted by injustice, there is a sense of power in invoking international law and bringing international attention to their communities. That gives them inspirational fight and resolve to continue their organizing. One organizer who I did speak with sort of detailed the sense of empowerment that he witnessed incarcerated women gain as they provided testimony on the lack of adequate mental health resources and exposure to violence in LA County jails. The notion that their struggle would be brought to the attention of others outside of the domestic systems that have perpetuated these conditions sort of solidified their commitment to challenging the conditions of their confinement in the jail system. While the federal government of the US is less vulnerable to international scrutiny, the level of international attention that comes with the utilization of mechanisms such as the UN or the Inter-American Commission on Human Rights does put pressure on local governments specifically. So what we saw in Ferguson was a good example of this. Advocacy at the United Nations around the killing of Michael Brown and reframing the incident and the violence against protesters in the aftermath as a form of torture is believed to have reduced violence against protesters later when the decision not to indict Officer Danielson was made. In setting the tone for policing the demonstrations, the National Guard instructed officers to act with regard to valuing the protection of life over property and cautioned that the image of local government politicians was at stake. While concerns about image are by no means indication of any radical change in policing practices, this outcome did sort of hint at the possibilities of international public shaming that can have a direct impact locally. Similar efforts by the organizing group We Charge Genocide in Chicago to bring international attention to the violence of policing in Chicago is similarly believed to have made an impact with the production of powerful images of advocates protesting silently within the halls of the US. And then finally, I do want to make the point that the effectiveness of this mechanism should not be overstated. The incorporation of this framework it remains to be fully measured, and it has to be part of a carefully coordinated broader organizing strategy. So moving forward, as state and local governments try to distance themselves from the policies of the Trump administration, there is hope that this advocacy strategy could prove more useful. The idea is that local governments may be more responsive in an effort to distinguish their policies and practices from those of the federal government that is viewed as particularly egregious. And as human rights advocates, it's our responsibility to ensure that accessibility to these mechanisms is available to organizers on the ground and do our part to work alongside these movements in the quest for justice.
While everyone's thinking, I was wondering if, and I guess this is for Safa, in what ways do you think that an advocate can have the biggest impact in addressing parole-related issues? Like, what would you like to see a broader community be doing?
I think that there are a lot of things that advocates can do, and I think it varies a little bit depending on where we are in the country. For example, in New York, I think a lot of the advocacy happens around pushes for legislative change, which is certainly important and a great way for folks to have an impact in terms of what's happening with our parole system across the country. I also think that needs to happen in coordination with folks who are incarcerated. In Illinois, for example, there is a bill that was presented that was actually drafted by people inside. And I think amplifying those voices are critical, since they are the ones that are going through this process, often without advocates in the room with them. And I would certainly like to see more people advocating for individuals. So encourage folks to understand what the system is in their own state. In Alabama, anyone can really advocate for an individual before the board. You don't have to be an attorney. So there are a lot of different ways that advocates can have a positive impact and can contribute to decarceration efforts.
Yes.
So, where you were saying that in some of these cases, in a few minutes, when a decision is made on parole, so what are the typical reasons why people are rejected for parole?
And that's a great point, and it highlights something that, for example, in Alabama, the board does not need to give a justification for why someone is granted or is denied parole. So if someone is denied, an advocate can try to ask the board for some sort of explanation, so that you can then go back to your client and tell them what they might be able to do for the next time around. So in a lot of cases, an explanation doesn't have to be provided. And that's part of the issue, that these processes are often shrouded in secrecy, and we don't really understand what the decision is being based off of. And you have a lot of cases where individuals have done absolutely everything that they possibly can. They've earned doctorates while they've been incarcerated. They've gone through all of the programming. They have a solid plan for what they would do in terms of housing and employment when they come out, yet they're still denied, and that can happen over and over again.
Yes, over here.
Yeah, what, can you name some of the limitations that you became frustrated with in your role?
Yeah, absolutely. I, in past experiences, I've had an opportunity to, when I was working with clients, really take time to get to know them and build trust. And it was daunting to go into a prison and asking, a young person who had been incarcerated for a long time, who had essentially grown up in prison, to say, this is your one shot for the foreseeable future. Please trust me to do a good job, and please, tell me, all the things that have happened to you and why you've ended up here. Some tough questions to just get into right away. So that's obviously not an ideal situation. And I think part of it was, really not knowing what to control for, what to expect when you were advocating. It was really just a matter of being as prepared as you possibly could, give it your all, and really work with that individual to ensure that they have a communicable plan. I think that's the most important thing, at least in Alabama and probably elsewhere, is to really present a solid plan for that individual of what's going to happen when they're let out, and where are they going to go live, and what are their plans, and what have they done while they've been inside to set themselves up for success. But the odds are against a lot of people, and I think the lack of transparency is one of the most frustrating aspects.
I saw a lot of hands. Is any of the questions for Jennifer? Because I want to make sure she gets a chance to address. Dick?
You used the word movement lawyer. The ordinary lawyer in these contexts tries to control the client. What was different in that context? Did you, for example, ever get into a situation when you thought, as a lawyer, trained as a lawyer, I would not go down that road in a particular tactic, but the movement dictates the tactics? Is that a tension, or is that what shall I say, a liberation of the lawyer to follow the client?
Yes, that's a great question, and I definitely think there is a tension. The reason why lawyers go to law school and get trained in the law is because we like to go to court and litigate, and sometimes that's not necessarily in the best interest of our clients or the movements that we work with. So a general rule in movement lawyering is that you only actually go to court if you've really had an at-length discussion with the clients in the movement about whether or not that's in their best interests.
Great. Any last question? Yes, Tom?
How are the members of the parole board selected? What's their tenure? And is it possible to have a role at that entry point?
Yeah, that's another great point, and another way that that the process varies across the country. Typically, the governor has some role in either appointing directly, having a supervisory role, toward the members, or at least approving in some way who's sitting on the board. And currently, with the controversy that's happening in Alabama, there's actually been a shift in the chairperson on the board. It's a 3-person panel in Alabama, but there is no sort of limit in terms of who, no set qualifications for individuals to be before the board, which is, yet again, I think you're pointing to an area that most likely could use some reform, and maybe some kind of consistency across the country in terms of who's making these decisions and how they're chosen and for how long.
And Jennifer, any last comment on how you see this notion of American exceptionalism beginning to break down and this rise of recognition of the U.S. having human rights issues, where you think that's headed and how we could strengthen that as a community?
Yeah, so one thing that I definitely had conversations with other human rights attorneys about was training attorneys who work in the area of police violence and litigating these cases in federal court to also consider bringing in the human rights framework into their work. So this is something that isn't frequently done, but just bringing more awareness and education around this approach is something that we're thinking of doing.
Interesting. We actually just had a conversation. I was at Facebook earlier this morning, and one of the issues is really trying to impose a human rights framework in the thinking of institutions, and I can see how there's a direct parallel between communities that don't often use that as a set of guiding principles for decision making. Well, I remember being a PhD student and getting an A+ in a class because I was the only person when all the tech went down who was prepared to jump up, and in this case we have 2 rock stars that kind of filled that need, so please join me in thanking them.